So let's continue this discussion. Joining me now, constitutional attorney Seth Berenzweig. Seth, put simply, these states argue that presidential candidate Donald Trump is ineligible under the 14th Amendment's insurrection ban. From a legal and a historical perspective, how remarkable, how significant is this case?
Well, this is really groundbreaking. We've never seen anything like this at all from a legal or a historic perspective. The Supreme Court is probably not going to be very happy to have to delve into this because of the great political sensitivity, but they're really going to have very little alternative. As a practical matter, the Supreme Court, in terms of their appellate review, has a litmus test in terms of the kind of cases that it is likely to approve, and one of them is the risk of inconsistencies in the various different jurisdictions in the United States. Well, certainly here we see that coming, and we see a groundswell of these different results that are headed slowly towards the Supreme Court here in Washington, D.C. On the one hand, you have Maine and Colorado for a disqualification ruling, and then you have Minnesota and Michigan ruling in the opposite. So although the Supreme Court probably would rather focus on other things, we are likely going to see a Supreme Court review. It will likely be under an expedited and briefing procedure, and therefore this is absolutely a first from a historic and from a legal perspective.
So it's historic, it's groundbreaking, unprecedented, but still there is a very definite clock on the calendar right now. You've got the Iowa caucuses in 13 days. States have got to get their ballots finalized. And do the courts feel that sense of urgency?
They do. I don't think they're going to be able to meet the requested deadline in Colorado. We're not going to see something within days, but I do believe that we'll see something within a month or two. It will probably be expedited because the Supreme Court is well aware of the fact that this is something that is going to have to be resolved. We can't have dozens of inconsistent litmus tests that are flowing through all of the local state court proceedings. So, for example, if you look at Maine, the Maine local process is very different from even Colorado. In Maine, you have a hearing in front of the Secretary of State's office, and then she issued a letter ruling that's appealed to the local state court. The process is different, the rulings and the substance is different, so we will definitely see an expedited result. It will also be interesting to see what standard of review the Supreme Court does. There are many that say, well, you've got a 6-3 split on the conservatives, so therefore they're wondering if they'll rule in favor of Mr. Trump. However, conservative analysis on the Supreme Court historically has also adopted concepts known as originalism and textualism, where they could apply it in their literal terms as to whether the disqualification clause is self-executing. So things will get very busy in the coming weeks.
Yeah, so if the Supreme Court does decide to take up this case, what are some of the issues that must be decided?
Sure. So in Colorado, the main issue was whether or not the presidency, in the office of the presidency, constitutes an officer within the meaning of the 14th Amendment, Section 3. And although the lower court concluded that Mr. Trump was not an officer within the meaning of the clause, the Supreme Court there ruled the opposite. That seems to make sense because it is the office of the presidency, so to conclude he's not an officer is unique. But there are a number of legal issues that go through different lenses. There will be procedural issues the court could consider as to whether the plaintiffs have standing. So there's going to be issues with regard to also the determination of an insurrection. Do keep in mind, however, that the insurrection is an insurrection as to the Constitution, not an insurrection against the United States, and that's important because that's a little bit more of a precise focus. So there will be procedural and substantive issues, and we can expect the Supreme Court to have this within their review within the coming weeks.
What do you think about what some Democrats are suggesting, that the 3 justices appointed by President Trump should recuse themselves?
Well, I think that's a little simplified. I don't believe that that's enough for recusal. If we really wanted to dig into recusal, which is a fascinating issue, that might relate more so to Justice Thomas because his wife was at the Capitol. She didn't enter the Capitol, but she was present during January 6th. There are text messages that became subject to the administrative record in front of the January 6th committee. So that's the one justice that I think could be suggested for recusal, but I think that he will refuse to recuse. I just don't see that being within his fiber. He's not going to step away from one of the most consequential decisions in the history of the Supreme Court, certainly the biggest case that they've seen in this realm since Bush v. Gore. So definitely an added element to the controversy, but I'd be shocked if anybody recuses themselves.
Fair enough. Seth, thank you so much.